Hello and welcome to Verdictum. This is Kanchan and today I'm going to explain to you a few interesting judgments of this week from the Supreme Court. A bench of Justice B.R. Gavai and Justice Sanjay Karol thus observed a medical practitioner guilty of contempt of court may also be so for professional misconduct, but the same would depend on the gravity or nature of the contemptuous conduct of the person in question. They are, however, offences separate and distinct from each other. The former is regulated by the Contempt of Court 1971 and the latter is under the jurisdiction of National Medical Commissions Act 2019. While citing WB Administrative Tribunal vs. SK 2012 11 SCC 76, the bench also stated the court has time and again asserted that the contempt jurisdiction enjoyed by the court is only for the purpose of upholding the majority of the judicial system that exists. While exercising this power, the court must not be hypersensitive or swung by the emotion but must act judicially. The court held this court has no hesitation in holding that the punishment handed down to the contemner is entirely foreign to the act and therefore unsustainable. The court, in awarding such punishment, showed complete disregard for the statutory text of the Contempt of Court Act 1971, which is abundantly clear in respect of punishment that can be imposed thereunder. The bench also referred to Supreme Court Bar Association vs. Union of India, which reads, suspending the license to practice of any professional like a lawyer, doctor, chartered accountant, etc., when such a professional is found guilty of committing contempt of court for any specified period is not a recognized or accepted punishment which a court of record either under the common law or under the statutory law can impose on a contemner in addition to any of the other recognized punishment. The bench also noted that subsection 1 of section 12 of the Contempt Act only prescribes simple imprisonments not exceeding 6 months or a fine not exceeding Rs 2000 as punishment for contempt. The bench of Justices C.T. Ravi Kumar and Sudhanshu Dhulia ruled that the High Court's reasoning is not acceptable at the Section 319 CRPC application stage. They emphasized that the merits of the evidence should only be assessed during the trial through witness cross-examination and court scrutiny. The High Court's action in the present case, prematurely examining evidence at the Section 319 stage, were criticized. Additionally, the High Court failed to consider the significance of the accused facing charges under various IPC sections, including Section 149, which pertains to being a member of unlawful assembly. In this case, the appellant before the court was an informant in the case and was a prosecution witness in an FIR registered under Section 458, 460, 2323, 302, 148, 149 and 285 of IPC 1860, read with Section 25 of Arms Act. As per the allegation, 15 assailants had broken open in the complainant's house to assault the inmates armed with lathis, guns and pistols. However, after the trial commenced and the complainant was being examined as PW9, he disclosed the entire event as an eyewitness. In his examination in chief, where he had assigned the roles to 3 assailants as well who were named in the FIR but not made accused in the charge sheet. As per the statements made by PW9, when the assailants finally left the house, they left after firing from their weapons, pursuant to which an application was moved under Section 319 of Code of Criminal Procedure for summoning those 3 people as accused, so that they may also face the trial, which the court allowed, but the order was set aside by the High Court in revision. The High Court had observed that the matter can be looked from another angle. It is the case of the complainant that the petitioner armed with a gun had come to the place of occurrence along with the other co-accused. However, it does not seem that the common pursuance that a person coming with a predetermined mind at the spot with a gun would flee without even firing or attempting a shot. This clearly points towards the false implication of the petitioner. The Supreme Court then, while referring to subsection 1 of Section 319 CRPC, was of the opinion that it is the judicial discretion of the trial court to summon a person as an accused who is so far not an accused in the trial if evidence has appeared before the court To our mind, the court had no alternative here but to summon the accused person, considering that now it has an evidence before it in the form of the statement of PW9. In our considered opinion, the High Court has not appreciated the matter in the true perspective of Section 319 CRPC. The judgment read further. Accordingly, while allowing the appeal, the bench set aside the order of the High Court. The two-judge bench of Justice Abhay S. Oka and Justice Sanjay Karol held a workman who has worked for 240 days in an establishment would be entitled to be made permanent, and no contract or settlement which abridges such a right can be agreed upon, let alone be binding. The Act, being the beneficial legislation, provides that any agreement, contract or settlement wherein the rights of the employees are waived off would not override the standing orders. An appeal arose out of the judgment of the Bombay High Court wherein it confirmed the award passed by the CGIT, rejecting the demand of the appellant union for reinstatement with full back wages. The respondent company was involved in a commercial airline flying aircraft for transporting passengers and cargo, and the appellant represented around 169 workmen temporarily engaged on a fixed term contract by the respondent in various cadres like loader cum cleaners, drivers and operators. The appellant contended that the workmen were treated as temporary despite completing 240 days in service in terms of the Bombay Model Standing Order and despite the nature of the work being permanent and regular. The respondent claimed that the workers were not entitled to permanency as per the settlement entered between the union and the company. The workmen raised dispute and the matter ladding up for adjudication. However, the CGIT, relying upon Section 25H of the Industrial Disputes Act 1947, held that there will be no retrenchment since the non-renewal of the fixed term contract did not amount to be as provided under Section 200BB of the said Act, and thus there was no question of re-employment of the concerned workmen. While relying with one of the issues, the court said, insofar as the respondent company is concerned, the appropriate government is clearly not the central but the state government, since the respondent is not within the meaning of Section 2B under the control of the central government. The present case falls under the latter part of the section. Thus, the appropriate government means the state government. The Bombay Model Standing Order would be applicable to the parties. Regarding another issue, the Apex Court noted that the appellant is entitled to all the benefits as per the Bombay Model Standing Order. Accordingly, the court allowed the appeal and quashed the order of CGIT and judgment of the High Court. The two-judge bench of Justice S. Ravindra Bhatt and Justice Arvind Kumar observed, democracy has been held as a part of one of the essential features of the Constitution. Yet, somewhat paradoxically, the right to vote has not yet been recognized as a fundamental right. Yet, it was termed as a mere statutory right. The electoral or the voter's right to know about the full background of a candidate evolved through court's decision is an added dimension to the rich tapestry of our constitutional jurisprudence. The bench said that the right to vote based on an informed choice is a crucial component of the essence of democracy. The appellant was a successful candidate in the election conducted of the Zahirabad Parliament constituency in the year 2019, and he was declared elected by defeating the vote of the respondent with a margin of 6,229 votes. The respondent preferred an election petition under the Representation of People Act 1951, alleging that the appellant furnished false information. When the matter reached High Court, it rejected the respondent's election petition, but the Apex Court, however, set aside the order. The Supreme Court, after considering the submission of the Council of the Parties, noted, this right is precious and was the result of long and arduous fight for freedom, for Swaraj, where the citizens had an inalienable right to exercise her or his right to franchise. This finds articulation in Article 326 of the Constitution, which enacts that every person who is a citizen of India and who is not less than 21 years of age on such dates as may be fixed and is not otherwise disqualified under this Constitution or law made by the appropriate legislature on the ground of non-residence, unsoundness of mind, crime or corrupt or illegal practice shall be entitled to be registered as a voter at any such election. The court said that if the appellant contentions were to be accepted, there would be a denial of a full-fledged trial based on the acknowledgement that material facts were not suppressed. whether the existence of a criminal case where a charge has not been framed in relation to an offence which does not possibly carry a prison sentence or a sentence for a short spell in prison, and whether conviction in a case where penalty was imposed or material facts are contested. Accordingly, the Apex Court concluded that the challenged judgment cannot be faulted and hence dismissed the appeal. Thank you and keep watching Verdictum, the dictum of truth. Subscribe to our channel and download the Verdictum app on iOS and Android to keep yourself updated with latest legal developments.